Okay, good afternoon, everyone. Welcome to the Maryland Public Service Commission's case number 9472. The purpose of our meeting today is to receive testimony on the joint motion for approval of agreement of stipulation and settlement for the Pepco rate case. So why don't we, first let me ask if there's any housekeeping before we call up witnesses. Okay, hearing none, why don't we then, we'll begin with Pepco and Mr. McKeel. Before we call up your first witness, if we want to take care of getting some testimony and evidence, why don't we do that?
Yes, Your Honor. I guess I should have spoken up for housekeeping. I would ask that the stipulation and agreement be marked as Joint Exhibit 1.
We will mark that as Joint Exhibit 1.
And I would ask that that be moved into evidence.
Without objection, Joint Exhibit 1 is admitted.
And then I would also ask that the notice of local public hearings be marked as Pepco Exhibit 2. And Mr. Chairman, did you want me to go through my list here?
Yeah. Why don't we, well, Pepco 2 is marked. Hang on just a second.
Yes, I'll wait.
This is Pepco 2 we're handing out right now. So, Mr. McKeel, we have your list. Why don't I suggest this for two of the testimonies on your list, what you are going to propose as to be marked as Pepco 4 and Pepco 19 are settlement testimony. So we'll go ahead and just mark those for now and admit all the other testimony as we go.
Thank you.
Okay.
That's what I would ask. And then I would also ask that our application be marked as Pepco Exhibit 21 and be admitted into the record. Sorry, I neglected to put that on our list.
Why don't we, since we haven't marked anything else yet, let's hold off on that.
Okay.
And let's, so we'll begin with Pepco 3, if you want to just run down the list.
I'd ask that Pepco Exhibit 3, McGowan Direct, be admitted.
Pepco, what we'll do is we'll just mark them.
Okay.
We'll go through and mark and admit them all at once. All right.
All right.
Pepco 3 is marked.
Okay. McGowan Settlement be marked as Pepco Exhibit 4.
Pepco 4 is marked.
Clark Direct be marked as Pepco Exhibit 5.
5 is marked.
Havert Direct be marked as Pepco Exhibit 6.
6 is marked.
Zeminski Direct be marked as Pepco Exhibit 7.
7 is marked.
Zeminski Supplemental Direct be marked as Pepco Exhibit 8.
8 is marked.
Zeminski Additional Supplemental Direct be marked as Pepco Exhibit 9.
9 is marked.
Wolverton Direct be marked as Pepco Exhibit 10.
10 is marked.
Wolverton Supplemental Direct be marked as Pepco Exhibit 11.
11 is marked.
Wolverton Additional Supplemental Direct be marked as Pepco 12.
12 is marked.
Murphy Direct be marked as Pepco Exhibit 13.
13 is marked.
Murphy Supplemental Direct be marked as Pepco 14.
14 is marked.
Murphy Additional Supplemental Direct be marked as Exhibit 15.
15 is marked.
Blazunas Direct be marked as Pepco 17.
17 is marked.
Blazunas Supplemental Direct be marked as Pepco 17, I'm sorry.
Right, supplemental direct is 17.
Yes. Blazunas Additional Supplemental Direct be marked as Pepco 18.
18 is marked.
Blazunas Settlement Testimony be marked as Pepco 19.
19 is marked.
And McNeely Direct be marked as Pepco Exhibit 20.
20 is marked. And the application is 21.
And then the supporting information that was filed, the updated information updating to actuals.
That's a May 8th filing?
Yes,
Yep.
I believe May 8th is the date.
Yep.
Be marked as Pepco Exhibit 22. Or March 8th, yes, I'm sorry.
Sorry, March 8th.
3/8, that's March, yeah. Sorry.
Okay, so
I would move the admission of all of the Pepco exhibits except for Pepco 4 and Pepco 19, Your Honor.
without objection, they are admitted. Are we ready to call up our first witness?
Yes, Your Honor. Pepco would call up Kevin McGowan.
Good afternoon.
Please swear and affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Mr. McGowan, will you state your name and position for the record?
My name is Kevin McGowan. I'm a Vice President of Regulatory Policy and Strategy for Pepco Holdings and Pepco.
Have you caused to be filed what has been marked as Pepco Exhibit 4, the settlement testimony of Kevin McGowan?
Yes, I have.
And do you have any corrections or additions that you need to make to that testimony?
I do not.
And if I asked you those questions, would your answers be the same or similar?
Yes, they would.
Do you have anything else that you would like to add before I allow you to be cross-examined by the Commission?
Yes, just a brief statement. It's been a while since Pepco has settled a base rate case in Maryland. In fact, no one in the office can remember when Pepco was able to settle a rate case in Maryland. So on behalf of the company, I would just like to express our appreciation for the parties to work together to reach a settlement in this proceeding. The settlement is essentially a unanimous agreement. GSA did not sign, but they also filed a letter not opposing the settlement. So it's essentially a unanimous agreement. Settlement is good for customers. The Tax Cut and Jobs Act of 2017 really provided a unique opportunity for us to provide a $15 million rate reduction for customers while also providing a recovery of investments the company's been making to improve reliability and customer service. The settlement allows the $15 million rate decrease to be implemented on June 1st without the time and cost of a fully litigated proceeding. If the settlement is approved by the Commission, I would note that to facilitate the approval and implementation of the rate decrease on June 1, the company has attached tariff sheets to the settlement agreement that have been reviewed and approved by all parties to the agreement. Thank you.
With that, Your Honor, I would move the admission of Pepco Exhibit 4 and tender Mr. McGowan for questions from the Commission.
Okay, Pepco 4 is admitted. All right, we will go to questions from the Commission. Good afternoon, Mr. McGowan. Good to see you.
Good afternoon.
I just had a couple of questions. First of all, thank you for your work on this case and for bringing a settlement before the Commission. We appreciate your efforts and your company's efforts, as we do with all the parties. The one question I had, the $9.7 million one-time bill credit, which captures the federal tax reduction savings from January 1 to, I guess, through May 30th, correct?
That's correct, yes.
And is that going to be given back as a flat kind of per customer credit on the residential side, or is that a volumetric credit?
So the 9.7 will be allocated to the customer classes based on the distribution revenue. So that'll set the amounts per bucket. And then for the residential customers, it'll be on a per customer basis.
Meaning each residential customer will get the same.
That's correct, yes. So it's about $10 per customer is what we calculated.
Okay. I saw in your testimony that you're presenting as the average residential customer in terms of the settlements rate impact, which would be a decrease of $1.64 per month, correct?
That's correct, yes.
And so that average residential customer usage is 812 kilowatts?
Today it is, yes.
And has that, over the last year or two, has that average usage changed? Has that gone down over time?
It has. Over the last, 3 or 4 years, we see the average residential customer usage declining. It hasn't declined much this year in the last 4 months, but it's around 812, 811 kilowatt hours. But I think 3 or 4 years ago, it was close to 1,000 kilowatt hours. We used to quote customer bills based on 1,000 kilowatt hours, but it steadily has declined over the last 3 or 4 years.
Okay, thank you. My last question, I think, is in the last Pepco rate case we had, which was in 2017, there was the issue of the $18 million request that was related to the proposed change in the method of income tax accounting for system assets installed before 1981.
Yes, that's correct.
Is that addressed in this settlement? That request which was not approved by the commission in the last case?
It is. In fact, it's let's get the paragraph for you. So it's in paragraph 5C. It's where the parties agree to use the flow-through method for the pre-81 removal cost, and then we'll calculate the method based on the dispersion method. And so with the Tax Reform Act, by lowering the tax rate, it lowered the impact of that on customers. And so in the last rate case, there was a discussion whether we should adjust rates one time or over a 10-year period. And so as part of the settlement, we've agreed to just make the one-time adjustment to rates and incorporate that into the settlement so that we won't have to come back every year for the next 10 years asking for an increase on that.
Okay, so from the last case, I recall that was OPC's recommendation that it be spread out over, I guess it was over
10 years, that's
right.
correct.
And so the settling parties did not take that approach. They opted for the one-time.
That's correct,
approach.
yes.
Okay, all right. Thank you. Appreciate you answering
All right,
my
thank you.
question. Commissioner Richard.
Good afternoon, and
Good afternoon.
I also congratulate the parties for arriving at the settlement. I did want to understand a little bit about the impact of the BSA and overall how, well, I guess relative or comparative to what was going to happen. Do I understand correctly that there will actually be a 1.5% or 0.5% increase in residential rates?
So Witness Blazunas can talk more about the rate design, but in general, what happens in a rate case is, to the extent that there's a positive BSA adjustment because usage has come down, when you come to a rate case, you have to you want to reset rates such as the BSA goes back to zero. Mm-hmm. So it's not that rates are going up; it's just a reallocation of an adjustment that was in the BSA. When you take that to zero, you increase the residential rate so that it's sort of flat when you combine both together. So once that was done, the residential customers will see a rate decrease after the BSA adjustment. But when you look at it before the BSA adjustment and after the BSA adjustment with the the rate reduction, it does appear as though the bill is going up. But it goes up because the BSA is also coming down.
Okay, but in real terms, there will be a slight increase then in I guess, the bill to residents?
It's my understanding that there will be a slight increase in the rate, but the BSA adjustment comes down so that the residential customer will have a rate decrease.
Okay, in real terms. Okay, and I was just trying to understand how that would work. It's described in here as billing units have decreased, or so the billing units, is that a result also of residents decreasing usage for various reasons?
Right. So to the extent that the distribution target revenue is not being achieved, there will be a BSA adjustment for that, and that's what that relates to.
Okay, and that's related to the fact that customers aren't using as much electricity for whatever reason?
That's my understanding, yes.
Okay. All right, well, great, thank you.
Okay, thanks.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Good afternoon, Mr. McGowan.
Good afternoon.
First of all, I wanted to congratulate the parties on bringing a settlement agreement to us as well. As you might imagine, we don't know what the commission's going to decide on this, but I'm sure the parties are anticipating that should we decide to accept it, that their workload will be significantly reduced, and I'm sure many people are hopeful of that reduction in workload. So congratulations to all the parties on that potential eventuality. The first question I wanted to ask you is the trajectory of the company's projected rate case filing. So we've had some discussions about what that looks like over the horizon going forward, and I wanted to ask you how this settlement agreement could impact that I think previous discussions were the potential for a 12 to 15 month repetitive filing, kind of how this settlement agreement may impact that long-term view of the company.
Sure. So in Maryland, as you know, the costs are recovered on a historic basis. So we spend the money, we put it in service, and we recover the cost. And that's really the reason why the company needs to make annual rate case filings. Sales aren't growing to really offset the increased investments that the commission and the customers are asking us to make in the system. So that's the real rationale. The settlement is really around the rate case filing, which was a 2017 test period. And so it doesn't really impact or delay the next rate case filing. The parties did agree to stay out till December 15th because they didn't want the settlement to provide an incentive for the company to come in and file in July or August. And so it sort of keeps us on that same annual rate case cycle. But until really the recovery mechanisms and the way we recover costs are changed, I think the company in the foreseeable future will be on an annual rate case filing cycle.
It's easier for me to understand absent a Tax Cut and Jobs Act kind of implementation, but this settlement has kind of a variable in it that is hard to project how that affects the company's revenues going forward, at least in my mind, and how that may affect your filings corporately. So I appreciate your answer on that. Basically, you're going to stay on the same schedule that you had envisioned before.
That's correct, yes.
Okay. In our previous order on the TCJA, we, my words, ordered that any savings that are identified downstream be held and basically be made prepared and identified to the commission for a return to the taxpayers or to the ratepayers for the taxes that will no longer be paid.
Mm-hmm.
How will this settlement agreement affect those currently unidentified but potentially identified downstream tax savings?
So the settlement agreement does note that if we do find additional savings, that we will make a filing with the commission to inform them as to how we're going to provide those back to customers, and would do that as promptly as possible. We had committed to do that anyway, whether it's through the settlement or whether it was through Delmarva, Maryland, that if we do find savings, we will make a filing with the commission as to how we'll do that.
Very good. Thank you, Mr. McGowan. That's all the questions I have.
All right, thank you.
Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon, Mr. McGowan.
Good afternoon.
I've joined my colleagues in congratulating all the parties in reaching this settlement agreement. It's not easy to do so, and as you've already noted, and the fact that there hasn't been a settlement of a Pepco rate case in many years. So I was also interested in one of the items that I'm not sure if this was discussed as part of a settlement or not. It doesn't appear as though it was resolved at this point, but it's regarding the Benning Road remedial investigation. I was wondering if you could give us just an update on where things are with the study that the company is engaged there.
So the company is currently completing phase 2 of the remediation investigation. I believe it is scheduled to be completed the next month or two. And then the next part, and that'll be filed with the D.C. Department of Energy and Environment, as well as the public, so there'll be access to that report. And then the next piece of it, which is the remediation part, which will look at options to address any findings we find in the first part of the study. That will be completed and filed, we expect, by end of the year.
Okay, so in your testimony, you noted that there was a cost of $3.9 million. Is that the projected cost, the cost that we're looking at for the work that needs to be done here?
So the 3.9 is the Maryland portion of actual cost to date through December 31st, 2017. So that's actual cash that we spent on the remediation investigation report.
Okay. So there isn't a concern, was there a concern amongst the other parties that there was some additional expense that was out there that was not identified yet? Was that part of the reason why this wasn't addressed here, or is just that the work hasn't been completed?
So I think it's more the latter. The Benning Road environmental cost was sort of a new issue. Most of the issues in the rate case were fairly straightforward, and folks have seen those before. Because it was a new issue, parties were able to provide, or to ask discovery. We provided a lot of information, had some discussions on it. The parties got comfortable allowing us to start the amortization of that, but they hadn't quite got to a point in the settlement that they would allow us to set up a regulatory asset and get the full recovery of that. They wanted us to come back in the next rate case and provide, our rationale as to why a regulatory asset should be established, and bring that to the commission for a decision.
Okay. All right. The second issue that I wanted to question you about is related to our evening hearing that we had on Monday in Prince George's County. We had several customers, Pepco customers, that come there and testify about the concerns related to their bill and potential of a rate increase. And they also noted that for some of them they had some challenges in getting responses from the company, either for assistance with their bill or for questions about how their bill reached the levels that it reached. So I was wondering if, I know it's still a little early, it's only been a couple days, but is there a update, or is the company looking into those concerns? Because the customers did come to the hearing, they gave us their names and everything as part of the public record in this case.
Right. So, first, I appreciate the customers taking the time to come out and make those comments. It is an opportunity for us to hear where customers are and some of the issues they have with our company. Every customer that spoke at the meeting, we will contact them directly to understand more about what their situation is. And I've already had a discussion with our customer care folks as to some of the comments I heard about not being responsive, not being able to resolve the issue. We do have very high customer satisfaction rates. They're about 85% overall for Pepco, which is very good. But I think those comments certainly indicate that we have some work to do, and with some of our customers that aren't getting resolution to their issue. One of the things that we are focused on this year as one of our initiatives is first call resolution. It's our objective is to try to resolve the customer's issue on that first call. And some of the comments we heard at the meeting were customers called back once or twice and they still weren't getting the answer they needed. Sometimes if the customer has used more energy than they thought, sometimes there really is no resolution. But we want to make sure that at least they understand, and if it's a meter issue, that we've taken the time to go out and check the meter and kind of follow up with them and resolve their issue. But we will contact all those customers directly to make sure that we understand their issue and try to resolve them.
Okay. And I guess finally, since we have a second evening hearing in Rockville, Montgomery County next week, in the event customers appear at that hearing with similar concerns, will the company also make the same commitment to reach out to them if there's outcry or request for assistance?
Absolutely.
Okay. Thank you.
Thank you.
Mr. Chairman.
Commissioner Foley.
Good afternoon, Mr. McGowan.
Good afternoon.
I join my colleagues in congratulating all the parties for reaching a settlement, so thank you for that. Now, a question I have is a couple of specifics. What was the test year in the original filing?
I believe it was December 31st, 2017.
So it was calendar year 2017?
Yes.
Okay. So that the settlement reflects actual reliability plant closings through March 31st of 18, so that's 3 months, right?
That's correct, yes.
Okay, just confirming that. With respect to the derecho and Sandy recovery of $1.333 million over 1 year period, what happens after the 1 year period? You going to remove that, or what's going to happen there?
So the amortization becomes part of rates, and that will continue. And we made a commitment in the settlement agreement that we'll track those costs, and to the extent that if we don't file a rate case within a year, or if rates aren't adjusted and we actually over-collect that we'll track that amount and give that back to customers in the next rate case.
Well, you would automatically over-collect it, wouldn't you? Because that would be June through June, and you've said that you can't file before December. So wouldn't that be you're assuming you'll definitely over-collect, right?
If we do file on December 15th, rates would go into effect around July, so there might be a couple months, but it'll be a small amount.
All right, you're right. Okay. On 50, on the rate case expenses that are deemed to be included,
Yes.
can you tell me what kind of expenses those are?
So we had an outside witness on ROE that we paid, and also we had just some miscellaneous printing and rate case expenses.
Okay. Thank you. The staff testimony mentioned there was a question about the number of customers in the EV rate schedule. Have you all figured that one out yet?
I'm not familiar with that. If you could
Okay.
ask Mr. Blazunas, I believe he's prepared to answer that question.
Okay.
I think that's our EV rate. We had an EV rate schedule early on that had golf carts on it. It was a very big precursor before we had electric vehicles, and I think that may be the EV rate schedule that we're talking about, and that rate schedule is closed, but Mr. Blazunas perhaps can speak to it, but I think that's was the issue.
Okay, I was
Commissioner.
I saw it had been raised and was just seeing if it had been resolved. That's all I have. Thank you, Mr.
Okay,
McGowan.
thank you.
Thank you, Mr. McGowan. Appreciate
All right.
your testimony.
Thank you.
Mr. Chairman, for its second and final witness of the day, Pepco would like to call to the stand Mr. Peter Blazunas.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Mr. Blazunas.
Good afternoon.
Could you please state your name and your position for the record?
Yes, my name is Peter Blazunas. I'm a senior rate analyst in the regulatory department at Pepco Holdings.
Okay. Do you have before you your pre-filed settlement testimony on behalf of Pepco in this matter, which has been parked as Pepco Exhibit 19, consisting of 6 pages and 4 attachments?
I do.
Do you have any corrections or modifications to this testimony at this time?
I do not.
Okay. Your Honor, at this time I would like to move into evidence what has been marked as Pepco Exhibit 19.
Pepco 19, without objection, is admitted.
Thank you. And Your Honor, the parties to this proceeding have reached an agreement on how the tax credit called for in the settlement agreement under the Tax Cuts and Jobs Act is to be allocated and returned to customers. I would ask for leave just to ask a few brief questions of Mr. Blazunas so he can provide an overview of that agreement for the Commission's benefit.
Okay.
Thank you. Mr. Blazunas, have the parties to this proceeding reached agreement on how the tax credit called for in the settlement agreement is to be allocated and returned to customers?
Yes.
Can you please describe how the tax credit is to be allocated to customers?
Yeah, so pursuant to paragraph 5D of the settlement, the tax credit, or the tax credit regulatory liability will be allocated to the different classes on the basis of base distribution revenues from the company's Maryland 9443 rate case.
And could you also please describe how the tax credit is to be returned to customers?
Yes. For the rate classes, residential, RTM, GSLV, TMRT, SL, and TN, the one-time tax credit will be returned on a per-customer basis. For the 2 rate schedules that have fixture or pull attachment counts, and those would be OL and SSL, it'll be returned on a one-time per fixture pull attachment basis. And then for the larger commercial classes, which are MGTLV, MGT3A, GTLV, GT3B, and GT3A, we'll actually calculate a customer-specific credit. And the way we'll do that is for each of those classes, we'll pull from our billing system customer usage for the period January through May of 2018. And then what we'll do is for each class, we'll take the dollar amount allocated to that class and separate it into 2 buckets. So the first bucket will be dollars to be allocated to individual customers on the basis of their usage, their volumetric usage. Second will be a bucket that will be allocated to individual customers on the basis of their demand usage. And then what we do with each of those buckets in each class is we look at a customer's, say, KWH usage for the period January through May of 2018, and we look at that as a percentage of the entire class's usage for that period. And then we allocate them a credit according to that percentage.
Mr. Blazunas, can you please explain why the party's proposed approach for the allocation and return of the TCJA regulatory liability is just and reasonable?
Yes. So first, all the rate classes get to share in the allocation of the regulatory liability associated with the TCJA on the basis of already approved distribution revenues from our last rate case. And then secondly, the method I just described for the larger commercial customers, for returning it to those customers, recognizes that there is a diversity of usage within those customers. So instead of, say, a high usage customer and a low usage customer in the same rate class getting the same credit, the higher usage customer will instead get a higher credit, and the lower usage customer will get a lower credit.
And finally, Mr. Blazunas, have the tariff sheets that are attached to the stipulation and settlement for which the parties are seeking approval from the Commission, have those been reviewed and agreed upon by the parties?
Yes.
Thank you very much. That's all I have, Your Honor. The witness is available for questions.
All right, thank you. We'll go to questions from the bench. And Mr. Blazunas, I have no questions for you, but I appreciate your testimony. Commissioner Richard.
Thank you. I also appreciate your testimony, and I have no questions for you.
Commissioner O'Donnell.
Just curious, Mr. Chairman, very briefly, I wanted to ask you if you had considered or thought about or roughly calculated what the ratepayers would have received if we had set aside the rate case that was filed and being settled here and only considered the Tax Cut and Jobs Act, what they would have gotten back absent the rate case.
I apologize, I don't have that number off the top of my head.
Okay, maybe someone else downstream will think about that in the meantime, but I'm just curious.
I mean, I
not that it affects my thinking on the settlement agreement, but it's good to know to keep it in context, I believe, when we do get to decision making.
So on that, Commissioner, I think you can see in the updated testimony that there on the Tax and Jobs Act, I think there was some talk that number was 18 million approximately. Now, I'm not the guy that would give you the number, but I know that we discuss it in the additional. I think it's the supplemental direct testimony, not the additional supplemental direct testimony.
Okay, thank you.
You might look at Mr. Wolverton, I believe, did
Very
that.
good. Thank you. Thank you, Mr. Chairman.
Sure. Commissioner Linton.
Oh, yes, thank you, Mr. Chairman. I just had a question about the one-time bill credit. According to your testimony, it was determined based on the average monthly count of customers for the residential class. This is on page 5 of your testimony. At the time, how are you going to issue the bill credit to customers? Will it be only for customers who are customers of record at the time of the day?
Yeah, I think the way we're looking at it currently is to do it for customers on record as of May 31st.
Okay, so customers who are coming on afterwards obviously are not going to get it.
Correct, under that approach.
So what about, we've heard before about customers who are in the period where their service is denied, but they're still a customer because they have the opportunity to pay and have their service reconnected. Are those customers still considered customers of record? Will they receive access to the credit?
If they are customers when the credit is issued, then I believe it would show up on their bill.
So as long as they have at least an active account with the company?
Yes.
Okay. All right. Thank you very much. Thank you, Mr. Chairman.
Commissioner Herman.
Mr. Blazunas, could you help me understand or, explain, because it seems like rates are going up a little, no, they're going down a little, maybe just help us all understand exactly what's
going on?
happening here with the BSA. And I'll just tell you, my understanding was that I thought the rates were going down, distribution rates for residential customers were going down, but that the BSA is operating, and that in order for the company to recover what they were intended to recover based on the BSA, that decrease is outweighed by the BSA, and therefore rates are going up a little. Do I have that right?
Yes. If you want, I can kind of walk you through an
That would be
example
great.
with residential. So if you go to my first exhibit, the second page, it's the residential rate design.
All right. Oh, wait.
And let me
Sorry.
preface this by saying that in case 9443, we would have established revenue per customer target levels for the BSA, and that as a part of this case, when we look for our annual authorized revenues, what we do is we take those established revenue per customer levels and we multiply them by the number of customers in the test year. So for instance, if you look on that schedule, I believe it's line 9, you see that our total annualized authorized revenue is $260 million. Okay. What we're seeing, though, is our base distribution rates, as they currently are with current usage, are bringing in only $247 million. So, absent, this settlement, what we would see is we would collect the $247 million through the customer's base distribution rates, and then we would collect the $13 million through the BSA. Okay, so in essence, the residential customer's rate would be based off of $260 million. Now, with the settlement, what we have is this $5 million reduction, which will be placed on top of that. So instead of paying $260 million, having their rates based off of $260 million, it'll be based off of $254 million. Okay, and it's a little confusing because the $260 million would be split between something coming in through the base distribution revenues and the BSA. The $254 million, everything is rolled into the base distribution revenue. And then kind of a second thing that would cause upward pressure on rates is that you have decreases in the billing determinants that we use to calculate our rates. So if you look at a rate as just the amount we need to collect over the billing determinants, even if we didn't change the amount we needed to collect, but the billing determinants went down, that would cause an increased rate.
Okay, so the average residential customer taking SOS.
Yeah, so the average customer taking SOS will, using 812 kWh, will see a decrease of $1.64 or 1.31% relative to what they would have seen absent this settlement.
What is it relative to the current rates?
Well, so this $260 million is essentially embedded in the current rates.
Okay.
So absent doing something, we would be collecting the $247 million and then the $13 million.
Got it. Okay. And what about a residential customer taking supply? What happens to their distribution rates?
I don't have just the supply portion, but it would.
I mean, just the distribution portion.
Oh, just the distribution portion. It would be the same for SOS or non.
Okay, so it's the same.
SOS. It's the same. Yeah.
Okay. Okay. Thank you very much.
You're welcome.
Well, thank you, Mr. Plazunas. We appreciate your testimony.
Thank you.
Next, why don't we go to AOBA, and we'll bring in Mr. Oliver's testimony.
Thank you, Your Honor. After previous discussions with the Commission Secretary, it was determined that the Commission had no questions for Mr. Tim Oliver, so we would like to stipulate in his testimony, and I would like to mark that as AOBA Exhibit 1 and have it moved into evidence.
Okay. AOBA Exhibit 1, which is Mr. Oliver's settlement testimony,
Correct.
is marked and without objection admitted.
Thank you.
Thank you. Next, let's go to the Office of People's Counsel, Mr. Efron's testimony.
Thank you, Your Honor. Similar to AOBA, we had conversations with the Commission Secretary, and it was indicated there would be no questions for Mr. Efron, so we would like to stipulate that into the record. And we'd like to mark the direct testimony of David J. Efron that was filed on April 27th, 2018, as OPC Exhibit 1.
OPC 1, Mr. Efron's settlement testimony is marked and without objection admitted. Next, we will go to the Commission staff. Our first witness is Mr. Vanderhaden.
That's correct, Mr. Chairman. Before we actually call Mr. Vanderhaden to the stand, just to speed things up a little,
Sure.
I'd like to mark his testimony as Staff Exhibit Number 1, please.
Staff 1 is marked.
Mr. Baker's testimony as Staff Exhibit Number 2,
Staff 2 is marked.
and Mr. Smith's testimony as Staff Exhibit Number 3.
Staff 3 is marked.
And with that, staff calls Philip E. Vanderhaden to the stand, please.
Do you swear and affirm under the penalty of the perjury that the testimony you're about to give and the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Mr. Vanderhaden.
Good afternoon.
Did you prepare the testimony titled Testimony in Support of Stipulation and Settlement Agreement of Philip E. Vanderhaden that staff filed on April 27th, 2018?
I did.
Do you have any additions, deletions, or other changes or corrections you would like to make to that testimony?
I do not.
And does this testimony form part of your sworn testimony in this proceeding?
It does.
Your Honor, staff requests that Mr. Vanderhaden's testimony be admitted to the evidentiary record as Staff Exhibit 1.
Without objection, Staff 1 is admitted.
And the witness is available for the Commission's questions.
All right, thank you. Good afternoon, Mr. Vanderhaden. I want to also thank you and your colleagues for your work on this settlement and for bringing it to us. We certainly appreciate that. I have no questions for you. Commissioner Richard.
Join the chairman. It's praise for, again, all the parties who worked out the settlement. I did just want to ask just a kind of a question, communications question. So the staff, as they looked at the effect of the BSA, is the staff comfortable with characterizing this in total as a decrease in rates? You know, I do understand what's going on. We have an effective rate, we have a current rate, and we have a proposed rate. I'm just for communications purposes, would like to hear the staff, opinion on this. You know, since in reality, residential customers will see a slight increase in their rates. But overall, how do you and I can ask the other staff the same question.
Thank you, Your Honor. I think the word rates is often used meaning both revenue and the actual price that you pay per kilowatt. And I think it's important to clarify which of those you're talking about when you're talking about a rate decrease. We know that the revenue itself, the amount of money that is going to be collected from all of the customers is going to decrease by the amount in the settlement. And I think as you've heard the explanation from the company witnesses, it has to do with the fact that the base rate itself is written in the tariff is not the only.
And again, I understand that aspect of it. I guess the real impact will be an increase on ratepayers. And is there a way that we should be communicating that better than just blanket calling it a decrease?
Well, there would probably be a couple of ways you would want to describe to customers what their bill impact would look like relative to what it was previously. And I would like you to ask that perhaps to Mr. Baker, because we've prepared for some examples on what customers' bills are currently now and what they would be if you compared this summer bill last year with the bill that folks are about to see, as well as
What they would have seen.
right. So it's difficult to talk about the case 9443 rates that for the summer have not really been into effect yet, because that case was finalized in the fall. So those customers, that rate decrease or that rate increase from 9443 in the summer rates, customers have never really seen. I think perhaps the tail end of the period. So when they look at this year's June bill and they compare last year's June bill, they're not going to see 9443 summer rates in their June bill. They'll see rates from, I think, 9418. So there is that will be that won't look like a decrease to them, but it's because the 9443 rates, which would have gone into effect in June had we not had the settlement in the case, those never went into effect. So it's a little different. What we're explaining here is because we have the tax effect, we have kind of I want to call it a pancaking of rate increases, but we've had rate increases that are occurring in less than a full year's worth of time, and we've got there's an SOS rate that I think is decreasing slightly for them, as well as market rates are also going down. So if you look, a customer's going to look at their bill. They look at the total bill, there's a lot of things impacting that, supply rates as well as SOS rates, plus the fact that we've got this rate affected by the taxes, and also that we're dealing with more than one rate case within the calendar year that they're seeing different rates from.
Great. Thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Vanderheyden, just very briefly, I think I know the answer to this, but I'll ask it anyway, just to make sure. The agreement authorizes a ROE of 9.50%. How does that compare to the current ROE?
I believe that's consistent with what they were awarded in the previous case.
Okay. And so it's just status quo ante in terms of the authorized rate of return on equity.
Yes, Your Honor.
Very good. Thank you. That's all I have.
Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon, Mr. Vanderheyden. Thank you very much for your testimony, but I actually have no questions.
Commissioner Herman.
Thank you, Mr. Vanderheyden. I also have no questions.
Thank you, Mr. Vanderheyden. Appreciate it.
The commission staff calls Benjamin Baker to the stand, please. And, Your Honor, just out of consideration for the commission's comfort, Mr. Baker did prepare an enlargement on the first page of his first exhibit, which is kind of a summary page. So we are going to distribute that to the commission shortly.
Lloyd, this is
Yeah, come on.
this is great.
It certainly helps. Okay. Good afternoon, Mr. Baker.
Good afternoon.
Do you have in front of you the document? Okay, sorry.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter of intent is the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Baker, starting again, do you have in front of you a document titled Testimony in Support of Settlement and Exhibits of Benjamin Baker, which staff filed on April 27th, 2018?
Yes.
Did you prepare this document?
Yes.
Do you have additions, deletions, or other corrections you would like to make at this time?
Yes.
Can you please tell us what those are?
Yes. Page 10 of my testimony, deleting lines 16 through 19, starting at cents. Be at the word cents. Yeah. Page 12, line 2, I would like to change have never to have almost never. And page 16, line 1, change test year rates to test year billing determinants.
And with those changes, do you adopt this as part of your sworn testimony in this proceeding?
I do.
Mr. Chairman, staff requests that Mr. Baker's testimony be admitted to the evidentiary record as Staff Exhibit 2.
Step 2 is admitted.
And the witness is available for the Commission's cross-examination.
All right, thank you. Mr. Baker, good afternoon. Good to see you.
Good afternoon.
Since Mr. Vanderheyden, I think he passed a question to you. Our rule used to be that whoever passes a question has to buy lunch, but I'm not sure if that applies to your boss or not. Take that up with Mr. Vanderheyden, but I want to give you the opportunity to answer the question he passed your way.
Yes. So there were there were three different bill analyses put in front of the Commission, one by witness Blazunas and two by me. The two that I discuss on page page 11 to 12 of my testimony. In my first exhibit, I discuss or exhibit 2 of my testimony. I show the bill impact without a BSA adder, so just as the rates are going up. And then in exhibit 3, without a BSA adder, so basically without the effect of revenue decoupling. And in my third exhibit, I discuss the issue of the fact that the last rates from case 9443 have effectively never been seen by the ratepayer since they went into effect at the end of October. And so we wanted to show effectively what bills the customers were actually seeing from last summer to this upcoming summer. Since basically we really have an avoided bill analysis and an actual bill analysis. The answer is it really depends on how you want to talk about it. Traditionally, when the Commission discusses bill analyses, I believe they are looking at previous rate case to this rate case, but we're in a unique situation where from last year to this year there were two rate cases or two different sets of base rates that went into effect before June 1st when this proposed settlement would become effective. Would you like any clarification on any of those?
I'm good. Commissioner Richard.
Yeah, I
Yes.
appreciate the clarification, and maybe it was more of a philosophical question of how we should be appropriately communicating this, given that the rates were never paid by ratepayers, and I just want to make sure this is good news overall. Okay,
Right.
and so, but I did, as I read through all the testimony,
Right.
was just somewhat concerned, if people are really looking at their bills and they say, wait a second, there's a.
I think I would really focus on the message of that revenues are going, that the amount of revenue that's coming from the customers is going down. That's the message I would focus on. And so because, yes, effectively we have removed the amount of revenue that the company is going to recover from those customers. It just might happen because of revenue decoupling that the customer, when they're looking at that, depending on where the BSA is in a given month, may be seeing a bill increase or may not be seeing a bill increase. But it's really the fact that the amount of revenue coming from the customers over time will have gone down, absent if this rate case had not occurred. Now, in terms of what happened actually from last summer, my analysis basically showed that the bills were effectively pretty much staying the same as where they were. Like I said, about a 0.13% decrease, which is almost zero. It's about $1 savings across the year, because the summer rates from 9418 increased in 9443, larger than what the decrease is going to be here in 9472.
Okay, and so maybe it's just, we want to be clear, there's a proposed rate, which is where we're going, should we approve the settlement.
Mhm.
There is the effective rate, and there is the current rate. I think that's the way you put it.
Right.
We should be clear about that.
Right.
Without having to get into explanations of
Right.
BSAs
If you keep it
and
clear,
decoupling and all the
right.
things that would probably make most people get very confused. So,
Right.
Okay. The other question I had is just this discussion on the two-step going to a four-step
Yes.
allocation process, revenue allocation process. Why was it the decision of the parties to do this in a settlement case? Go to a completely different method?
So, I mean, as part of the settlement and bringing all the parties together, like since these different parties have opposing views, for them to come together on that rate design, I think is a good symbol that they signed that it might be an appropriate way. Me personally, when I look at it, I see that the four-step method affords, and I discussed this on page 9 of my testimony, line 7 to 15. I discussed why I think it's appropriate, and I believe this is basically the greater flexibility the four-step method affords towards addressing cost causation amongst the classes and helping correct these classes closer to a unitized rate of return of 1. So I think that, that's why I thought the four-step method was appropriate, even though this was a settlement.
Right, and that was, again, give it a settlement, and this is an opportunity when you're looking at a potential decrease,
right.
To maybe try to address some of the interclass disparities.
Right.
I just was interested to know if there was discussion among the settling parties, though, that the policy reason for the decrease is because overall there was a tax decrease and the federal policy to try to increase employment in jobs. So are we, I guess, forwarding it all by using this as an opportunity to again address these disparities in this circumstance? As opposed to maybe allowing the effects to go through.
So let me just
the current circumstances.
Right. So
I don't know if was there any discussion at all among the parties that this was maybe not the right time because of it's a tax cut to be looking at this question of interclass disparities.
So essentially, ignoring the principle. So in a sense, basically, instead of using the $15 million revenue reduction to decrease rates instead of or not decrease rates, but to as part of the fixing of interclass subsidization, you instead just allow it to flow back to the classes as is and allow the tax cut to operate as the feds envisioned. I would assume
that's basically what I'm asking. Yeah. Particularly in this case, since there will be the effect of a slight in real terms increase on residents in our state.
Yeah, so I'm not aware of those discussions occurring, but
okay. Fair enough. Thank you.
Thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Just, Mr. Baker, thank you for being here. I wanted to clarify in my mind, $9.7 million is going to be a one-time credit back to the customers, and that's based on the overcollections from the period January 1 to
May 31st, 2018.
May 31st. So, okay, so that's the one-time $10 and whatever it is per customer. Okay.
Yes.
And then the impact of the TCJA cooked into the settlement agreement going forward will result in a decrease of about $1.63 a month for the average customer using 812 kW. Is that right?
If you're using the effective rates based off of Peter Blazunis's testimony, I believe that is correct. I'd have to check his testimony.
I just wanted to make sure it was clear in my mind. So those two things said, did you hear the question I asked Mr. Blazunis about what the impact on the ratepayers may have been? And I'll go look at the council was giving me another place to look, but I just wondered if you had looked at what the impact on the ratepayers may have been absent the filing of this current rate case with regard to the Tax Cut and Jobs Act impact. How much might they have realized otherwise?
So let me just make sure I understand the question. If this rate case had not occurred, and instead the company had not given back the money, how that would have affected customers?
No. What I'm really trying to separate in my mind for perspective is what the ratepayers would have realized for taxes that they would have been. That overcollection would have continued unless we fixed it somehow.
Right.
How much is that? That's really what I'm asking.
Got it. Yes, I do not have that number in front of me. I have not looked into that yet.
All right. Very good. Fair enough. Thank you.
Commissioner Linton.
Thank you, Mr. Chairman, and thank you very much for your testimony, Mr. Baker. I actually didn't have any questions.
Thank you.
Commissioner Herman.
So I'll go to the EV.
Yes.
Have you resolved that with the company?
So yes, we can actually go to page 19 of my testimony.
Right.
And I'll also, I believe I have a data request exhibit on that as well that I cite. Let me find it. Okay. So, and then it's, and also my exhibits on, it's staff data request 216.2-2. But essentially, we, in the course of the, when the company was still seeking a revenue increase, in their supplemental direct testimony, they had, basically, they had filed the EV class in such a manner that it would have seen a large increase in their rates, which would effectively have been rate shock. And so we questioned what was occurring here. And so when they looked into it, they found that that a closed class had actually had more customers come onto it, but the energy usage of the class had remained about the same since the last rate case. So we agreed to use the previous rate cases billing determinants to set the rate for the EV class to avoid the rate shock. And then the company agreed to go and look into what is occurring with those customers in that class to understand how customers got onto the rate class. And I do not know at this point what they have found.
Okay. Okay. Thank you. That's all the questions I have. Thank you very much.
Thank you.
All right, thank you. We appreciate your testimony.
Thank you.
Mr. Baker.
Thank you, Mr. Baker. All right, the commission staff calls Jamie Smith to the stand, please.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Good afternoon, Mr. Smith.
Good afternoon.
Do you have in front of you a document entitled Testimony in Support of Settlement and Attachment of Jamie A. Smith?
I do.
And this document was filed by staff on April 27th, 2018, is that right?
That's correct.
Do you have any additions, deletions, or other changes you would like to make in this document?
I do not.
Okay. And is this document part of your sworn testimony in this proceeding?
It is.
Mr. Chairman, staff requests that Staff Exhibit 3, Mr. Smith's testimony, be admitted to the evidentiary record.
Staff 3 is admitted.
And the witness is available for the Commission's questions.
Very good. Good afternoon, Mr. Smith.
Good afternoon.
to see you. I appreciate your testimony. I have no questions. Commissioner Richmond.
Also, good afternoon. Thank you for your testimony, and I have no questions.
Commissioner O'Donnell.
I'm not going to ask my same question again.
You can actually. You can.
Okay.
I can tell you where.
Okay, good.
I don't have it on me, but I can tell you exactly where to find it.
Okay, fair enough.
If you look in my testimony, actually on page 3, where I talk about giving back the $9.7 million, it's on roughly line 24 through 28, 29, I'm sorry. So if you look at the bottom of that, where I talk about it, say, see, Pepco witness J. Zeminski supplemental testimony scheduled JCZ-SD-2. That's where you'll find the information.
Very good, Mr. Smith. Thank you very much. I will look there.
Welcome.
Thank you.
Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon, Mr. Smith. I have no questions.
Commissioner Herman.
Thank you, Mr. Smith. I have no questions.
Great. Thank you, Mr. Smith. We appreciate it. That's our last witness for our proceedings today. Any housekeeping before we adjourn? All right, seeing none, I want to thank all our parties again for bringing this settlement to us and for your testimony today. We are adjourned.
Thank you, Commissioners.